afternoon. Welcome to the Environmental Law Institute's Breaking News webinar, analyzing the consequences of Sackett v. EPA and looking ahead to the future. My name is Madison Calhoun, and I'm the Senior Manager of Educational Programs here at the Environmental Law Institute. We are so excited to see so many of you here today. Today's event will consist of short presentations from all of our speakers, followed by a roundtable discussion with time at the end for an audience Q&A. Please submit your questions throughout the webinar in Zoom's Q&A box, not the chat. You are welcome to use the chat to engage with one another and post observations, but please post your questions in the Q&A box. You can post them as soon as you think of them, though. There's no need to wait until the end of the webinar. The Environmental Law Institute has a long history of providing professionals and the public with timely, balanced information on wetlands, law, policy, science, and management to protect wetlands across the United States. This webinar is part of our wetlands work. While today's webinar is free to attend, we are offering the opportunity to donate in support of our work and the further protection of wetlands. There will be an option in the Zoom platform to donate via pledge, or alternatively, you can text the word wetlands to the number 707070 to donate. We will also share this information in the Zoom chat. If this webinar or our wetlands work has been of value to you in your work, we invite you to donate and help make laws that work for people, places, and the planet, most especially wetlands. Now we will go ahead and turn things over to Jim McElfish to start the program. He's our Senior Advisor of Research and Policy at the Environmental Law Institute and a longtime wetlands expert. He'll be moderating the session, and I'm going to go ahead and turn things over. Thank you so much to all of you for joining us.
Thank you, Madison, and welcome to all of you joining us to discuss the Sackett versus EPA decision. As all of you know, having registered for this event 2 weeks ago, the U.S. Supreme Court, acting in a wetlands case on appeal from the Ninth Circuit, ruled on the scope of the Federal Clean Water Act. The act was enacted in 1972 and amended significantly in 1977 and then again in 1987. The court's decision defined, or in some respects redefined, what the term waters of the United States subject to the Clean Water Act means. The decision of the court essentially finds that the U.S. Environmental Protection Agency, the Army Corps of Engineers, and indeed almost all of the lower federal courts have for 5 decades been applying the law to protect waters using federal protection, protecting waters that were not entitled to protection under the Clean Water Act. So, and in effect, this decision directly and immediately affects the legal status of many thousands of activities across the United States each year that either are covered by permits or general permits, or that might have been covered by such permits up until 2 weeks ago. Thus, it's important that we understand what this decision means and what comes next. And we're going to focus in this seminar pretty heavily on what our expert panelists feel may be coming next and what some of the possible responses to the decision might be. This matters a lot as federal regulators, state and local governments, tribal governments, infrastructure developers, water managers, flood control districts, landowners, private businesses, and conservationists determine what to do as they order or reorder their affairs and activities, and as many of them will need to do in response to the redefinition that the Supreme Court has presented us with. Fortunately, we have an excellent panel to help guide us through this. And as I mentioned, we're going to be looking as much as we can forward as opposed to what came before, although certainly we will look to some degree at some prior definitions and a little bit of prior case law as needed. We'll begin with 2 expert law professors, both leading experts in environmental law and on water, wetlands, and clean water law in particular. We'll lead off with Jonathan Adler, professor of law and director of the Coleman Burke Center for Environmental Law at Case Western Reserve University School of Law. He'll be followed by Robin Craig, who is the Packer Trustee Chair in Law at USC's Gould School of Law. And Robin has written extensively on this set of topics, including a recent ELR article, which I commend to your attention. Our two law professors will then be followed by Dr. Rebecca Kisslinger, who leads ELI's wetlands programs and whose research has focused to a substantial degree on state and local protection of wetlands and waters, and also done work in the area of compensatory mitigation, that is, mitigation that's required by permit to offset losses to waters of the United States or waters of the state. And then followed by Edward Ornstein, who is the environmental counsel for the Miccosukee tribe of Indians of Florida. Tribal perspectives will be extremely important because it's not only states and the federal government that have authority over these waters, but so do tribal governments on the lands that are subject to their jurisdiction. And the Miccosukee tribe's experience will be of particular interest, given that their lands are to a large degree located within the Everglades, a very complex system of waters and wetlands. And Edward will be guiding us through this. So we're going to give each of our panelists about 12 to 15 minutes, and we'll reserve the last half hour for questions. And I hope there are plenty of questions, and I invite you to leave those in the Q&A function. And I'll turn it over now to Jonathan.
Great. Well, thank you. It's a pleasure to be here. Happy to be part of this program. I'm going to make sure I can see the slides as well. There we go. So it's certainly great to be here to talk about Sackett versus EPA, or what I'm referring to as Sackett 2, Justice Scalia's triumph. This case, in many respects, for reasons I'll discuss, is confirmation of Professor Richard Lazarus's hypothesis that the current court's approach to environmental law is basically the approach to environmental law that Justice Scalia wanted, but that Justice Scalia was rarely able to put together a majority in support of. And for reasons I'm going to talk about, to understand this opinion and what it means, and certainly how the justices see it, one has to focus on what Justice Scalia wrote for a plurality of the court in the Rapanos case. So in terms of Sackett, it's worth starting with the Sacketts. The Sacketts themselves, oops, I can't see. There we go. The Sacketts themselves, if we could go to the next slide. There we go. So here are the Sacketts. Here's one of several pictures of their property that we will see. As folks will remember, the Sacketts had initially been before the court 11 years ago, seeking to challenge the EPA's position that they could not challenge a jurisdictional determination. Basically, the EPA had told them that their land did constitute waters of the United States. They disagreed, and they were at the Supreme Court 11 years ago arguing that they should be allowed to seek judicial review of that determination. When they sought cert again, a lot of the discussion about whether or not this was a good case to flesh out or help define the meaning of waters of the United States, there were really two very different conversations about this. Within the environmental community, a lot of the conversation focused on the fact that the Sacketts, they engage in development. This isn't a small family that just accidentally got ensnared in federal regulation, but rather folks that knew what they were doing and deliberately sought to develop their land, even though they knew the federal government didn't think they could. Whereas if you talk to folks in the property rights community, folks like PLF, their view was, here's a couple, they're a small business, and they've been to the court before, and they're still dealing with this this conflict 11 years later. They still didn't have certainty over whether or not they were covered by regulation. The other reason why folks wanted to, or were interested in this case as a possible test case for how to define waters of the United States was because, as we'll talk about, in the Rapanos case 16 years earlier, the Supreme Court had split 4-1-4. And in fact, in the initial cert petition that was filed on behalf of the Sacketts, the question they had asked the court to answer was simply, should Rapanos be revisited to adopt the pluralities test for wetlands jurisdiction under the Clean Water Act? That's not the question the court accepted, though. Slide. There we go. The question the court actually accepted was much broader in some respects, whether the U.S. Court of Appeals for the Ninth Circuit set forth the proper test for determining whether wetlands are waters of the United States under the Clean Water Act. What the Ninth Circuit had done, like most lower courts, was to adopt the significant nexus test, the test that had been embraced by Justice Kennedy in his opinion, his opinion concurring in the judgment in Rapanos, under the Marx rule that was generally understood as being the narrowest grounds for sustaining the judgment in Rapanos. And so the Ninth Circuit, like most lower courts, like the federal government, had been focusing on the significant nexus test. And so the question was merely put in terms of whether this was the right test or not. As noted in the case, next slide, please. The reason we care about this test, we all know this is a super quick review. The Clean Water Act requires you to have a permit to discharge a pollutant. Discharge of pollutant means any addition of any pollutant to navigable waters from any point source. Slide. And navigable waters in turn is defined as the waters of the United States. And so the question initially put to the court was, well, does the Sackett's property constitute part of the waters of the United States? Next slide. Here's just an aerial view of the Sacketts. This is a picture from the Pacific Legal Foundation, who represented the Sacketts. The yellow box is where the Sackett's property is. This is when it was still wooded, but I think it's before they had begun development on the site. As you can see, it's near Priest Lake, but separated at least somewhat by a road and some houses. There are also some intermittent streams to the north of the property, although non-navigable. Next slide. This is, again, the way the Pacific Legal Foundation presented it, trying to highlight the fact that the water that the Sackett's property was closest to was not navigable waters, whereas the navigable water that folks would be concerned about being Priest Lake was to the south. And so the issue for the court was this part of the waters of the United States? Next slide. As noted already, the test everyone thought they were applying was Rapanos versus United States. 5 justices had concluded that the EPA had been adopting too expansive, the EPA and Army Corps had been adopting a too expansive an interpretation of waters of the United States. 4 justices did not, but those 5 justices were split. I think 2 advances. I'll give my animation. There we go. So green line dividing the court on the judgment, but the red circle, there were only 4 justices for adopting a fairly narrow test about what constitutes waters of the United States. And what to do with the Sackett's property in light of this prior disposition was the real question. In terms of what the Sackett opinion did, next slide. And then I think, there we go. The court unanimously rejected the significant nexus test. And that's a pretty big deal. And that was pretty surprising. I think pretty important because everyone had been assuming that a significant nexus was sufficient to establish jurisdiction over land as part of the waters of the United States if wetlands on a given property had a significant nexus to navigable waters. The assumption was that was sufficient. And the court unanimously rejected the significant nexus test. The court also unanimously concluded that there was no jurisdiction over the Sackett property. I think that's also significant. I will confess that was a surprise. I've gone back multiple times to the opinion to make sure I read that correctly, because one possible disposition, the disposition we in fact saw in the Rapanos case, would have simply been Ninth Circuit, you applied the wrong test. EPA and Army Corps, you applied the wrong test, but maybe under a better test, you could establish jurisdiction. Not a single opinion in this case holds that out as the proper disposition of this case. Justice Kavanaugh's concurrence in the judgment explicitly says that he agreed that he and those that join his opinion agree significant nexus is not sufficient, and that the Sackett's property is on the far side of the line for jurisdiction. And so wherever we draw the line, the Sackett's property is not included. Next. Where the court is 5-4, this is where I'm going to spend my remaining time unpacking a little bit. One way to understand what they're 5-4 is the definition of what is adjacent. All of the justices agree that some wetlands adjacent to at least some waters, certainly navigable waters, are part of waters of the United States, but part of the split between the majority and the opinion concurring in the judgment on whether or not adjacent is defined really narrowly, adjoining wetlands, those wetlands with a continuous surface water connection, versus those that may merely be neighboring. And related to that, a split over whether or not there is a need for a continuous surface water connection, whether there needs to be a genuine boundary drawing problem in terms of when waters and lands begin. That clearly is a part of Justice Alito's opinion for the court that is too restrictive in the view of the concurrence. Next slide. Could have picked out a bunch of quotes from the Alito opinion. One thing that's striking in this opinion is that everywhere he wants to tell us what the holding is or what the court's deciding, he quotes and cites to the Rapanos plurality. And I think that's important because there are some issues that Justice Alito does not really address that Justice Scalia did address in the plurality. I think it's fair to assume that where the Alito opinion is silent, one should look to the Rapanos plurality for guidance. I think it's fair to say that the justices that join the Alito opinion understand that opinion as an articulation of the same test or holding of as the plurality in Rapanos, that the CWA's use of waters encompasses only those relatively permanent, standing, or continuously flowing bodies of water forming geographical features that are described in ordinary parlance as streams, oceans, rivers, and lakes. Next slide. I think that significant that Alito also makes very clear what this means for the party asserting jurisdiction, for the EPA or the Army Corps if they want to assert jurisdiction over adjacent wetlands. They first have to show that the adjacent body of water is part of waters of the United States, i.e. a relatively permanent body of water connected to traditional interstate navigable waters. And second, that the wetland has a continuous surface connection, right? So it has to be next to something that would indisputably be part of waters of the United States, and there has to be this continuous surface connection that makes it difficult to determine where the water ends and the wetland begins. This is a very narrow test, and the opinion makes clear the burden on demonstrating this is on the party that wants to assert jurisdiction, which will usually mean on the Army Corps or the EPA. This is a test that does not provide for much room, if any, for deference to the agencies. The burden is upon them to make this demonstration. Next slide. Justice Kavanaugh, his separate opinion concurring in the judgment. I wrote concurrence across the top of the slide. I should really say opinion concurring in the judgment. After acknowledging, the agreement on the ultimate judgment, Kavanaugh explains that this continuous surface water connection, in his view, in the view of the justices that join him, is too narrow. That interpreting adjacent to merely mean adjoining is too narrow. The continuous surface water connection test is not only, in his view, inconsistent with the text of the statute, but also, and I think this is an important divide between the majority and the concurrence, it departs from 45 years of consistent agency practice and the court's precedents. In his view, adjacent has always been understood to be something that should be understood more broadly than the majority is interpreting it here. And next slide. In terms of understanding the split between the justices, I think some of the commentary has said, oh, well, you know, one side cares about the text and the other side doesn't. Certainly the opinions in this case make those sorts of suggestions about each other. I don't really think that's fair. I think they're both focused on text. They're just emphasizing different things. Alito is emphasizing text with a focus on the operative provision and the word waters, and not allowing any interpretation to give waters an interpretation that is counterintuitive or that pushes against our natural understanding of that word. Justice Kavanaugh focused more on understanding the provisions of the Act together in light of consistent agency practice. And I think that division is significant, in part because one thing that's been an undercurrent in this court for the last few years, and certainly will be a big deal next year, is the extent to which the court should care about things like consistent agency practice and the way the agency has consistently or historically understood a statute. There are overtones here of the debate we are likely to see next term about Chevron deference as well. So that's, I think, a way to understand this split. I think another way to understand this split is that the majority is very concerned about there being a constrained understanding of federal jurisdiction that does not push the boundaries of federal power. That's certainly something we saw in Scalia's plurality in Rapanos, but also something we saw in Kennedy's controlling opinion, or what we used to think of as the controlling opinion in Rapanos, and that we also saw in Swank. And one passage in the Scalia opinion, or sorry, in the Alito opinion that highlights that is on my next slide, where he makes a point that was also made in the Swank opinion, but not made that forcefully in Rapanos, that the court requires Congress to enact exceedingly clear language if it wishes to significantly alter the balance between federal and state power and the power of the government over private property. Regulation of land and water use lies at the core of traditional state authority. If you go back to the Swank opinion, you see this idea very prominent in that opinion, arguably driving the Supreme Court's opinion in Swank. It receded a little bit into the background in Rapanos. Here you see it again. While Justice Alito says this is unnecessary to the court's conclusion, I think it is significant that it is there, and certainly something that connects what the court's doing here to what we've seen it do in cases like, say, West Virginia versus EPA. Last slide. Some questions going forward, and some that I know some of my co-panelists are going to address. One is tributaries and headwaters. A lot of emphasis on this continuous surface water connection, but how far can we follow that? How far upstream or downstream can we go with surface water? Does there have to be a potential of navigability? Related to the potential for navigability, while Justice Alito doesn't stress the constitutional aspects of this, Justice Thomas, in a separate concurrence joined by Justice Gorsuch, does. While the court doesn't rely upon constitutional concerns as an opinion, it's certainly worth thinking about the fact that the wetlands program has for a few decades now been understood to be one of the environmental programs arguably most vulnerable to constitutional challenge on enumerated powers grounds. If Congress seeks to revisit this opinion or by revising the Clean Water Act and expanding jurisdiction, we will have to think about what clues this opinion gives us about the constitutional limitations on federal regulatory power. Next question, or next bullet. I've already suggested that I think the court doesn't give a lot of room for the Army Corps and EPA to give their expert opinion about the nature of connections. The focus on surface water connection is kind of focusing on things that any of us can see, as opposed to something that requires scientific or hydrological expertise. I think there are some questions about how firm a limit that is, and whether there is room for the Army Corps and EPA to explain to courts about hydrological connections that may not be readily apparent. And then lastly, there are some questions about how this interacts with Section 401, how this interacts with NPDES permits, how it interacts with the court's holding in Maui versus Hawaii Wildlife Federation. Of note, there is a whole section in Justice Scalia's Rapanos plurality, which goes into why narrowing the scope of waters of the United States as applied to wetlands does not necessarily narrow the Clean Water Act for traditional pollution control to the same extent. Justice Kavanaugh made that same point in a separate opinion in Maui. Justice Alito doesn't talk about it. And so whether or not we can rely upon the discussion in the Scalia opinion or what Kavanaugh had said in Maui is I think, a question that is worth considering. And I think one of the questions that Robin is going to get to next. Thank you very much.
Thank you, Jonathan. And let me turn it over to Robin.
All right. Thank you, Jonathan. Thank you, Jim. So moving on, yes, what exactly does Sackett mean? I'm going to pick up some of the threads that Jonathan laid out. Next slide. So just visualizing what are the statutory jurisdictional waters, just keep going, keep going, keep going, keep going. So, you know, this is the full spread. If you look at the text of the Clean Water Act, it applies to the ocean, the contiguous zone, and the navigable waters. The navigable waters, obviously the phrase we care about, because it's the one that comes up in these cases, is waters of the United States. The ... that Jonathan left was the territorial sea. And why I have the ocean, the contiguous zone, and the territorial sea in green is no one has ever seriously argued that those are not under federal jurisdiction. And I don't think even Thomas and Gorsuch would attempt to do that. So, you know, worth remembering in this context that we do have waters that no one is questioning are jurisdictional. The ocean is clearly one of them. Traditionally, navigable waters, however you want that phrase to mean, navigable waters is a legal term of art. Unfortunately, it's at least 50 legal terms of arts, depending on context. And so there are waters that are navigable under most definitions from the US Supreme Court in most contexts. And they include waters that are navigable in fact in commerce. So the Mississippi River is in no danger of being declared not a water of the United States. The Columbia River as well. Anything subject to the ebb and flow of the tide, also a navigable water not in danger of losing jurisdiction. So like I said, I like to start off by reminding everyone that we do have waters that are unquestionably covered by the Clean Water Act, regardless of what the details of waters of the United States actually means. That constitutional issue came up in a very interesting way in this case. It was in part a statutory interpretation issue, that what Congress meant by navigable waters in 1972 was what it understood to be federal navigable waters for purposes of the Commerce Clause. That in itself is an interesting and not as easy to decide issue as Thomas and Gorsuch made it sound. But viewing it as a statutory interpretation issue is still a different question than viewing Congress's Commerce Clause authority as a straight up constitutional matter. So I just want to emphasize, and Jonathan alluded to this, if that constitutional aspect ever gets unpacked, it's going to be much more complicated than the Thomas concurrence made it sound. Next slide. All right, Jonathan had one picture of the property. Here's another picture of the property. I'm bringing it up because, you know, in many years of the Clean Water Act, a property this close to a navigable water, Priest Lake, that had soggy patches on it, you would assume you had to talk to the Army Corps of Engineers. You know, whatever the Army Corps engineers said at that point, you would assume you had to do it. And obviously we are in a different world now, but it is worth seeing both how close it is to Priest Lake, how close it is to other wetlands, but also how divided it is from Priest Lake. And that's kind of where this case was operating. Next slide. All right, what I wanted to pull out from the amicus briefs were some of the projections of what Sackett would mean, what the choice between those two tests, significant nexus and continuous surface water connection to a relatively permanent water, would actually mean on the ground. I am borrowing these with permission from some of the amicus briefs that were filed with the Supreme Court. Next slide. But there were attempts to illustrate to the court what this could actually mean. And you can see, particularly in the West, and this is where I think the import of Sackett will be felt the most at the federal level, is in the West, where we have a lot of waters that are intermittent, that dry up on a regular basis, even naturally that dry up on a regular basis because the water is being pulled for irrigation and municipal uses. This could get to be a really interesting opinion in terms of defining what does relatively permanent mean? Relatively permanent compared to what? If it means relatively permanent in a year-round sort of sense, and there were, Alita's opinion made clear it doesn't have to be water in it every single day of the year, but what exactly is the borderline, and do we get to compare it to its natural flow and natural drying in areas where that is in fact the natural pattern of waterways? But again, you can see dramatic potential reductions in jurisdictional waters here in New Mexico. Next slide. An example from the South Platte watershed in Colorado. Again, fairly dramatic reduction. This will be true in many places in the West. Next slide. Even in places that are wetter, like Minnesota, the test will make a difference. And so this is an example from Minnesota. Next slide. And so that brings up two questions that Jonathan left that I want to go to. Actually, three questions. So first off, we have new regulations from the EPA and the Army Corps of Engineers issued at the beginning of this year. Those regulations are permeated with the significant nexus test. And as a result, one of the next up things, and I didn't have a good way to illustrate this, is that those regulations are going to have to be revisited. They have severance provisions in them, but it's hard to sever out the core tests that they were relying on. So those regulations will have to be revisited. Another issue that Jonathan mentioned on his last slide, tributaries. Tributaries are arguably on much safer ground, and this goes in part to the reflection back to Justice Scalia's opinion from Rapanos. So we're looking at a continuous surface water connection. Well, if you look at any surface water system of tributaries, arguably the entire thing has a continuous surface water connection that, as long as you end up with a traditional navigable water at the end, which most of them do, you've got the whole watershed. So that's one potential argument going forward. That is a potential subject of a new rulemaking, even though we can't expect that the agencies will get deference for anything. Even applying the continuous surface water connection test, we could have a relatively broad approach to tributaries that remains. That is also consistent with Justice Scalia's opinion from Rapanos, which Jonathan alluded to. He has a moment in the Rapanos decision where Justice Scalia tried very hard to distinguish Section 404 and 402 on the theory that in Section 402, when you dump a bunch of fill material into a wetland, it more or less stays put. Now, I've always said proving Justice Scalia has actually never seen a dredging and filling operation, but nevertheless, his thought was it more or less stays put, that you don't have pollutants flowing downstream. And he was very careful to say, hey, if you're talking about industrial toxics, industrial pollutants, they do flow. That's the whole point. That's why you have to get smaller waters in the Section 402 context to make sure that those industrial pollutants don't get to the larger waters. So I think there's a very solid legal argument, even from the perspective of Justice Scalia's Rapanos opinion and Justice Kavanaugh's understanding of it in the County of Maui decision, that tributaries are in, this aspect of Clean Water Act jurisdiction has not changed. Remains to be seen. I hope this is one of the issues that the agencies take up in their rulemaking, because I think they can be very consistent with it. The next big issue will be what happens when Sackett meets County of Maui. So County of Maui, 2020 decision involving the Section 402 permit program. A court different enough from this court that it's an open question as to whether this court would have reached the same conclusion as the County of Maui court did, but nevertheless, it remains precedent for the moment. But in the Section 402 context, the County of Maui's sewage treatment plant, which you see here in the lower right, was partially treating its sewage, pumping it into injection wells, which then connected up with groundwater, flowed out to the Maui coast and hurt some coral reefs. Took about 87 to 110 days to get there. There were dye tests to prove it. And the question was, did this facility need a Section 402 NPDES permit? And the court said yes. It invented the functional equivalence test, made it a factor-based test for lower courts to develop, but said, time and distance are going to be the most important factors, but left it basically as if you're putting pollutants out there in such a way that they flow relatively quickly to a relatively close traditional navigable water and remain identifiable as your pollutants, you need an NPDES permit. So the question that Sackett raises is, can you carry this over to the Section 404 context? That issue that Justice Scalia didn't want to think about is what happens when your dredged and fill material also flows down to a navigable water. I can make you the argument that if you discharge dredged or fill material into a non-jurisdictional water, but it flows relatively quickly to a bigger water and it is recognizably your dredged and fill material, Sackett would apply and you would still need a 404 permit for that. I can very easily see courts going exactly the opposite way, but where that line drawing will be important for the future. What has changed in getting rid of the significant nexus test, however, and I think this is important, is the significant nexus test allowed the EPA and the Army Corps to think about how what you were doing to a smaller water affected the larger processes of the aquatic system, the chemical, physical, and biological. And that meant when you were filling in a wetland, you got opinions like the Ninth Circuit's that this was affecting the ecological integrity, it was affecting nurseries, it was affecting reproduction, it was affecting nesting grounds, it's on and on and on and on. After Sackett, I don't think we can do that anymore. We are in a world now where we are tracking where pollutants go. And that may be one of the biggest changes that the Sackett case brought. Now, it does dovetail very neatly with County of Maui because that's what the court was worried about in County of Maui, but it is a significant change from significant nexus test and what exactly litigants will be worried about proving in court. So with that, I will turn it over to our next commentator.
Thank
And
you.
Rebecca,
Thank
take
you,
it away.
Robin. Really interesting set of issues and observations. Rebecca.
Hi, yeah, thank you. Thank you, Jonathan and Robin. So I'm gonna switch a little to talking about where the states are, what the state approaches are to regulating waters, given this, changing federal regulatory landscape. I'm gonna give a snapshot and talk a little bit about some opportunities moving forward. So you can go to the next slide. So as alluded to a couple of times, the change in jurisdiction are really going to put a substantial burden on many states to protect their state waters. One of the ways they can do this is through enacting and implementing regulatory programs, so permitting programs for impacts to wetlands and waters. In addition to those regulatory programs, there are also opportunities that states have already adopted or may contemplate adopting, other kinds of approaches that they may use to protect priority waters in their state. I'm going to talk a little bit about both. We can go to the next slide. So first up on the regulatory side, here's a snapshot of a map that we put together looking at current status of regulatory coverage. We have those states reliant on waters of the US or with no state regulatory programs in green. In blue, we have the states that have some broad coverage of non-WOTUS waters or waters of the state. And then yellow, we have states that have where their coverage may be for a specific set of waters or activities. So nearly half the states, 24 states, do not operate any independent state permitting scheme regulating discharge to non-WOTUS waters. They may apply Section 401 of the Clean Water Act of federal permits or licenses, but they do not have a state regulatory program. And of course, these are the states that are most vulnerable to changes in federal jurisdiction, and their waters will be most affected by these changes. The 19 states in blue are the states that have fairly comprehensive permitting programs. The coverage of these programs does vary. There are states like Virginia and Maryland and California, Washington through several programs that do cover most waters of the state. So they have fairly comprehensive. There are other states that have some limitations, for example, like New York, where their current regulatory program covers wetlands of greater than 12.4 acres or of unusual importance. That state, or New York, has recently amended that act in last year, April of 2022, to make the act successively more protective, including reducing the size needed for regulation to 7.4 acres. And in these blue states, it's important to note that these states their waters are less vulnerable or will be less affected by changes in federal jurisdiction. And some of these states, the regulatory programs may not look too different given this change because they have joint permitting programs with the federal agencies. And so things may move forward looking quite the same. The yellow states, this last group of states, again, are the states that may have adopted specialized laws or regulations that cover certain activities or types of wetlands. And on the next slide, I'm going to go through a little bit. We have sort of categorized these in a couple of buckets. The first of those buckets is the kind of isolated waters permitting states. So those states that enacted permitting programs following the 2001 Supreme Court decision in Swank. These states include Ohio, which enacted an isolated wetland permitting program where they define isolated wetlands as wetlands not subject to the Clean Water Act. Indiana has a isolated wetland permitting program, and their permitting program was designed to regulate wetlands of 3 classes, from class 1, which are the more disturbed wetlands, all the way through class 3 wetlands, which are the more pristine or habitats for rare or threatened or endangered species. North Carolina is another example of these isolated water permitting programs where they enacted a permitting program following Swank. All 3 of these states have since made some changes. I'm going to talk about that on the next slide. The second bucket we have here is permitting programs for most non-WOTUS state waters. So one example of that is DC. They adopted emergency and final rules following the 2020 Navigable Water Protection Rule and from the Trump administration. And these rules identify the district's waters as critical areas in need of protection and subject them to a permitting program, wetland and stream protection permitting program that applies to non-WOTUS waters. Our third bucket are permitting for designated or specific state non-WOTUS waters or activities. So states that have enacted permitting programs for a specific kind of wetland or a specific activity. One example here is Arizona's Surface Water Protection Program, which was enacted in 2021. It protects some important non-WOTUS waters, especially for their value in drinking water, fishery, fishing, and recreation. And it only applies to non-WOTUS waters on the state's list. So it's a specific list of wetlands that are covered by this program. It directs the director of the Arizona Department of Environmental Quality to apply the state's water quality standards to these waters, but it is not a permitting program for dredge and fill. Another example is Illinois in this category, and Illinois has a program that protects some wetland or applies a permit for some state-funded activities in some wetlands of the state. And the last category hit we have here is a case-by-case regulation, and our example here is West Virginia. West Virginia does not routinely permit dredge and discharges into non-WOTUS waters, but they do assert authority to regulate some activities on a case-by-case basis. So on the next slide, as I promised, I just wanted to talk a little bit about some recent changes to these programs. And as I mentioned, Ohio, North Carolina, Indiana all have these isolated waters programs. All have made recent changes. In Ohio, following the 2020 Navigable Waters Protection Rule, Ohio sought to extend their permitting program to ephemeral features with regulatory action in 2020. However, last year in 2022, the Ohio legislature rejected that regulatory change and reverted the scope of coverage of waters to the federal scope. North Carolina is also seeking to adopt final regulations that would cover a gap in the state's protection between their isolated waters protection permit program and any changes in federal jurisdictions. So they adopted temporary regulations in 2021 and have required permits for those specific set of waters. And these are specifically non-adjacent, non-isolated wetlands, those that are put at risk by the Sackett decision. However, permanent regulations in North Carolina are still on hold because they're under review by the state's legislative controlled Rules Review Commission. And so the fate of that program is uncertain. And one more change in Indiana. As I mentioned, the permitting program is organized by class of wetlands, and they've rolled back the types of wetlands that they are protecting under that program, removing protection for class 1 wetlands and class 2 wetlands that are less than 3/4 of an acre. And the other one I mentioned was Arizona, new surface water protection program. There have been recent changes also in California, and as I mentioned, New York. So next slide. So that's kind of the snapshot of this, where the states are in their regulatory programs. We have states fairly comprehensive, many states with no permitting program at all. So I think at least in the immediate or short or even medium term, states, are going to have to think about other kinds of protection programs outside of regulatory programs, and these are going to become really important. And so I wanted to run through some of these other approaches that states and local governments might, be able to take or might contemplate adopting in order to protect their waters and wetlands. One area is local governments can use their land use regulatory powers to protect wetland buffer areas. Wetland buffers provide important protection for wetlands, for water quality, and quantity purposes. Local governments can derive authority for protecting wetland buffer areas through state wetland programs or critical area programs, but they can also use their local government land use authority to protect wetland buffers. In 2008, ELI produced a guide for local governments and wetland buffers, which reviews some of the different approaches local governments have taken to protect these areas. As with buffer requirements, local governments can also have authority to create permitting programs for wetlands and waters. There's a number of states where their wetland regulatory programs also provide for local regulation. So like Washington, New York, Virginia, critical areas laws in Maryland, and the State Growth Management Act in Washington also give local governments substantial authority to protect wetlands through permitting programs. And states without these kinds of state regulatory programs, local governments can also use their land use powers to create local regulatory programs. And there are several examples of local governments with wetland protection ordinances. Another opportunity is for states that do not have regulatory protection of specific kinds of waters is to regulate particular activities. So these could include regulations that prohibit or provide specific permits for dewatering of aquifers or for groundwater protection programs like in California and Arizona. There are programs that may regulate in-stream flows or withdrawal of water from watersheds. Lots of states have stream alteration or habitat protection permit requirements that may apply to these waters. On the non-regulatory side, there are several states that have engaged in spatially explicit planning to identify and prioritize habitat, important wetland and floodplain habitats. Examples are like Colorado's potential conservation areas, the Maryland Green Print. These identify specific areas that are worthy or that are priorities for protection. And they may be tied directly to funding schemes within the state, or maybe freestanding, or could be used for multiple management purposes, but do identify important areas. Some states have adopted water quality standards for non-WOTUS waters. Even in states that don't have specific regulatory programs or permitting programs for wetlands. Certain states have adopted wetland specific water quality standards, but more commonly states apply their water quality standards to wetlands. And these could provide a basis for some state protections. Conservation banking may be an opportunity. So conservation banking provides a mechanism to offset impacts to species listed as threatened or endangered under the Endangered Species Act or a state equivalent. So conservation banking may provide opportunities to protect some of these important features in the landscape, especially if this target species is dependent on these habitats, so certain vernal pool species or other kinds of species. One big category is voluntary conservation and restoration. Every state has some kind of voluntary conservation and restoration program. They leverage the efforts of landowners, nonprofits, and the public to protect and restore wetlands and other waters. They take a huge variety of forms, from engaging citizens in wetland monitoring. There's lots of participatory science programs, paying citizens to remove invasive species, funding landowners to change agricultural processes, or purchasing easements from landowners, providing technical assistance. There's lots of opportunity through voluntary conservation and restoration at the state level, and most states are engaged in these efforts. And then finally, I think one big area, we just had a webinar recently on wetlands resilience and new technologies, and several of our speakers said, well, wetlands are having a moment. And I agree. I think there's a lot of more attention being paid and policy development around the use of around restoration and conservation of wetlands, floodplains, and other kinds of ecosystems as natural infrastructure and nature-based strategies for hazard mitigation, for water management, for resilience. I think there are lots of opportunities to build partnerships among the wetland agencies at the state level with hazard mitigation and resilience agencies to leverage investment in protection and restoration of these ecosystems for these other purposes like hazard mitigation. And we're seeing these kinds of efforts growing at FEMA, at the Army Corps, and the water resources side at the state level and with nonprofits. I think there's lots of also opportunities with tribes, and I'll leave that to Edward. Next slide. I did just want to kind of finish on a few words on compensatory mitigation under the Clean Water Act. This is an area, as Jim mentioned earlier, where we do a lot of our work. As Jim said, Section 4.4 of the Clean Water Act requires that permitted impacts be compensated. This compensation program operates under a set of regulations that was finalized in 2008 that include requirements for siting, implementation, review and approval, and management of compensatory mitigation projects. The mitigation market is billions of dollars annually to restoration of these wetlands and waters. Many of these projects are accomplished through third-party restoration experts, mitigation bankers, and MFP programs. This is a map I pulled from the Army Corps' RIDIT site, which tracks mitigation projects done by mitigation banks and MFP programs. There are over 4,000 sites in the US and Alaska as well. That are mitigation banks and MFP sites. So it's a big program. There's lots of money going to restoration. And I think that with this decision, this landscape is going to change dramatically. It will change substantially. The requirements for compensatory mitigation will largely be thrown back to the states with regulatory programs and compensatory mitigation requirements. Those states that we highlighted in our map at the beginning, as will the mitigation providers that are engaged in this work will their business may now largely be thrown back to these states with regulatory programs. So that is where I will end, and I look forward to the discussion.
Thank you, Rebecca. And I see a lot of interest in the chat as well as the Q&A on this topic. So I think this is an area of great interest. Let's turn to Edward.
Good afternoon, everyone. Thanks for listening in. I'm Edward Ornstein. I'm a member of the Southeastern Muskogee Nation, a state-recognized tribe in Alabama, and I work as the Special Counsel on Environmental Affairs for the Miccosukee Tribe and as a Vice Chair for the American Bar Association's Native American Resources Committee. Happy to be here and to share a slightly different perspective from Indian country. If we can move to the next slide. And in fact, if we could alternate between this slide and the following slide for the next minute, what these two maps show, imagine I'm an IT genius and I know how to overlay one map on top of the other. What these two maps show are the Obama-era wetland delineations and the location of tribes, federally recognized tribes within the United States. You'll notice that pretty much everywhere there's wetlands, there's tribes. In other words, wetlands are Indian lands, and especially in areas like the Great Lakes or the Louisiana Bayou or the swamps of Florida, there are tribes, there are sovereign nations which can regulate in addition to states. If we can move on to the next slide, please. So as some of my colleagues have highlighted, the opinion handed down by the courts is not necessarily the last word on this issue. Over the next few months or years, our profession is going to interpret and reinterpret this decision in courts and agencies and tribal and state governments and academia and law review articles. So rather than focusing on these sort of direct implications, which at this point in our presentation you probably have a good grasp on, I want to focus on what open questions we have and encourage y'all to start thinking about innovative answers. For example, I work in the Everglades, which is not unlike many wetlands around the nation, which are divided by artificial infrastructure. If you're working in a space like that, maybe a good question to ask is, what is continuous surface water connection? If, say, there's a gate that is controlled by an agency that, if left open, would create a continuous surface water connection, but if closed, might sever that connection. If there's an artificial impediment to the natural flow of the water, can there be an artificial tool to create flow? If I take a 24-inch culvert and I ram it through a levee, have I created continuous surface water connection? Do agencies need to account for this in their management of those structures? If closing a gate means it's no longer a water of the United States, is that something that agencies need to take account of? And even if there's not surface water connections, I think we're all on this panel thinking about the implications of the County of Maui decision, because what's the lag time for a pollutant in the wetlands to make it to a water of the United States? And can that navigable water be used as a proxy to regulate that source surface water body? I think the answer is definitely in a gray area, but it's worth exploring. And what's the impact for a tribe or state that's assumed regulatory authority from the EPA? Many tribes have done this through the Clean Water Act's treatment as a state program, and many states have, of course, done this as well. And does there need to be any impact if you are working with a sovereign government like a tribe or state? Alito said in his opinion that states can and will continue to exercise their primary authority to control surface water pollution by regulating land and water use. So that's clearly how the justices are thinking about it. And we should probably take that cue. We could go to the next slide, please. So if y'all will indulge me for a moment, let me give a brief recounting of some of the basics of tribal civil regulatory authority and jurisdiction so that what I say next has some context. And if you're familiar with this information, I do apologize, but just hang in there with me for a second. So tribes are sovereign nations. They're not just reservations, they are national bodies, and they are recognized as such by a very long line of case law going back to the maybe the late 1820s, but certainly the 1830s. That Marshall trilogy of cases, Cherokee v. Georgia, Worcester v. Georgia, Johnson v. McIntosh, all the way into the present day through cases like Santa Clara Pueblo v. Martinez or McGirt v. Oklahoma. So it's very clear that tribes are sovereign nations with all of the aspects of sovereignty that have not been explicitly divested by Congress or by the tribe itself. So that means that tribes are sovereign nations, sometimes to the exclusion of states. So we can look to cases from tribal gaming law, like California v. Cabazon, where we see a tribe seeking to authorize its own bingo hall without the approval of the state. We can look to Brendale to see the Supreme Court considering the interest balancing that's necessary to determine whether or not a tribe or a state might have regulatory jurisdiction in a certain space. And I think the Montana v. US case gives a very clear hook for tribal civil regulatory jurisdiction in Indian country, including over non-Indian polluters, because it provides an avenue for jurisdiction whenever there is a threat to the health, welfare, or political integrity of a tribal nation. And in addition to having those aspects of being a sovereign nation with the authority to regulate Indian land, tribal nations are often also federal regulators to the extent that they have assumed the Clean Water Act enforcement program through that treatment as a state. That's Clean Water Act 518 that has that treatment as a state language. And we've actually seen, not in the Supreme Court, but in the Ninth Circuit, the courts look at a tribal water quality standard and actually impose it off the reservation on an upstream polluter, the city of Albuquerque, and hold them to account to the tribe's water quality standards. So if we think to the beginning of my time here and looking at those maps, there's 576 federally recognized tribes in almost every watershed, if not every watershed in the United States. So if one tribe in that watershed and imposes, for example, a limit on total phosphorus, that may be extended to upstream polluters in the watershed. So these are things that I think are worth thinking about and considering when we're talking about tribal nations, that there's in fact two sort of levers that tribal nations can pull, their own sovereignty and that delegated authority. Next slide, please. Now, with all that jurisdiction and authority in mind, what strategies might be employed? Frankly, I think it's worth noting that this case isn't an isolated incident. There is a trend towards the devolution of regulatory power from the federal government. So I think if you're an advocacy organization, if you're a tribal nation, if you're, a private actor and you're thinking about how to make an impact, maybe one of those strategies is reallocating national advocacy resources to states. I live in Florida, and while some may expect Florida to not strongly enforce water quality or to be more business focused, there's been a lot of investment very recently from the state government into ensuring that the Everglades is healthy. And that is interest that comes from the interest of the constituency. And as I note lower down on this list, public relation campaigns need to be one of the things that as attorneys we're also thinking about, because maybe a combination of those public relations, of lobbying in the state, and of legal advocacy can get us to a different place in the state houses, even if it doesn't get us to that place in DC. And then tribes and states can interpret this decision in varying ways. You can't break the law, but if you have a reasonable interpretation of what's going on, and it might differ from how another state or tribe or federal agency is doing it, within your jurisdiction, you have the right to pursue that interpretation. And of course, there's tribal and state regulation. As I noted, there's some of that downstream enforcement power that may be latent, as the Ninth Circuit has considered it, and that may allow tribes or states to impose their water quality regulations on surrounding entities. And then, of course, the federal agency interpretation, the rulemaking, the guidance documents they put out in the next few months or years are incredibly crucial, because there's still, I think, a strong sense of deference to agencies. I mean, that may have been weakened by some recent decisions by the Supreme Court, but it's nonetheless an established body of the law. And I think that to the extent that agencies come to some sort of consensus about how to interpret this decision, that's going to have an impact on the courts. And you don't need to get to the courts if you have an agency that has a good idea, an innovative idea about how to approach these issues. And of course, before the Clean Water Act, before the EPA, most environmental law was done through mass torts. There was a group of folks affected and they had standing, then they could sue to, enjoin a particular activity. And that remains absolutely the case. If you live in a wetland and somebody is disturbing the water quality and it's affecting your drinking water, it doesn't matter whether or not the waters of the United States include your specific, body of water, because if you're impacted, you still have standing to bring this in court. So there's a lot of tools that we can begin to look to that are not necessarily based in a understanding of the Supreme Court's jurisprudence, but maybe based in our understanding of what kind of injury we might be sustaining. So I just want to encourage everybody to broaden their toolkits and consider how, particularly if you're an actor within a tribal government, how you might be extending your jurisdiction under that Montana exception, that health, welfare, and political integrity, or operationalizing your Clean Water Act treatment as a state authority, regulating a body of water that is still a water of the United States on your reservation, and noting how those impacts are traveling from adjacent wetlands. Next slide, please. I just want to encourage anyone, if you have any questions, feel free to reach out. I'm going to try to end here so that we have about 20 minutes left for questions. Thank you.
Thank you, Edward. Appreciate that very much. We've covered a lot of ground. We've received a lot of questions, and I'll do my best to tee these up and combine them where appropriate. But I've found this extremely illuminating as we've discussed these issues. One of the early questions I'm going to give to Jonathan is, So where does Justice Alito and the majority locate the need for a surface connection between the wetlands as opposed to any other sort of connection?
Yeah, so I mean, the short answer is in the word waters, which is, or the phrase, the waters of the United States, which is the definition for navigable waters. There's both emphasis placed on the fact that it's the waters of the United States, and that the meaning of that is not merely water, but a set of waters that could be understood as the waters of the United States, as opposed to, say, the waters of the states and the like. But also recognizing that historically the Clean Water Act has not been understood to apply to groundwater. And so it applies in the first instance to surface water, that the waters of the United States are surface waters. And then that is understanding the boundaries of that definition are basis for it. So that's the how I would characterize the logic or the understanding that the majority opinion is adopting, and then, as we discussed, rejecting what had been the view of the EPA for most of the last 50 years, that this should also include adjacent wetlands that have hydrological connections, which might not be on the surface, or at least not continuously on the surface.
This may be a related question, and I'll throw it to Robin. So how should agencies and landowners and others evaluate the duration or permanence of wetlands and their connection? For example, there are many wetlands that are periodically inundated, but don't maintain a continuous surface connection. How should those be addressed, or what's the likely approach that agencies will take?
Well, as I flagged, what exactly we mean by permanence or continuous surface water connection are areas that need to be developed. My reading of the court majority is that they're not going to tolerate big interruptions. They did make some allowance for small interruptions, like perhaps in a severe drought or a small seasonal interruption. But I would hope that at some future date, they would also take into consideration what the natural state of certain waters are. So I would speculate on the extremes. Waters that are connected only during flooding, I don't think they're gonna allow as WOTUS. On the other hand, at the other extreme, waters that are normally connected and the flow gets interrupted only because of a severe drought, I think they would let in, even this court. Where that line falls in between, I would say it's closer to the flooding end, that we're gonna see fewer exceptions, but that remains to be developed.
Can we borrow anything from Justice Scalia's notion that kind of rivers with seasonal flow might be in? What about wetlands with seasonal surface connection?
Well, this goes to Jonathan's point of how much of Justice Scalia's opinion is being adopted by implication. And he did make some allowances for that, although more enthusiastically when he was talking about 402 than when he was talking about 404. And so again, if they adopt Justice Scalia's opinion, we might have some broader leeway. Again, I think it's always going to be tied to natural condition, though. Would be my guess of where the court would go going forward.
Okay.
If I
There are
could
a
just add
number.
something
Go
real
ahead.
quick on that, is that if you go back, and this, for some folks, this may be deeper and more in the weeds than they want, but I think it's important, is that if you go back and read Scalia's Rapanos opinion, it implicitly assumes that there is going to be some boundary drawing by the agency. Throughout the plurality in Rapanos. There's hedging about how continuous it has to be, how much intermittent is too much, and so on. There's a lot less of that hedging language in Alito's opinion, and Alito's opinion is very explicitly says we're not going to defer to the agency at all, and that creates a challenge that Scalia's plurality as written might not have created, in that it's not as clear in the opinion where the gaps are that the agency can try and fill with its expertise.
Okay. I'm going to throw this one to Edward, and there are a number of questions about wetlands connected by culverts, and there are a number of wetlands that there might be culverts and a continuous flow over several miles, and they might go under roads and the like. At what point does a wetland become distinguishable, even though there is kind of a continuous surface hydrologic connection via culverts and other structures?
Thank you for that question. And it's definitely the one that's been on my mind a lot lately. Where I work, there's 2,700 miles of canals, something like 2,200 miles of levees, berms, dikes. The Everglades is a very infrastructure-rich area. So, I mean, if we think about this from a perspective of what's the natural condition, I mean, the natural condition doesn't include those artificial disruptions. Is there a point in time that something that's artificial becomes natural? I don't think so. But I think the proper answer here is the cautious one, that if you're a polluter, then you should be assuming that, yes, in fact, there is a continuous surface connection when it goes through a gate or is interrupted by a levee. And if you're someone who's trying to protect the environment, you want to argue that that is the case, but probably assume that it's not. And I think that we can get a sense of where some of the justices are on this question, but certainly not enough of the justices to be able to give a particularly educated answer. But to me, this is a very wide avenue for agency interpretation, and one that I think agencies and tribal and state governments can step into.
Thanks.
And if I can just throw in, I think this is one of the tragedies of the Supreme Court's addressing of waters of the United States, is that it will do it in 402 or 404, but it will never think about them simultaneously. And I think many decisions would have been tempered if they were thinking about the entirety of the act at the same time.
Okay. Yeah, thanks for that observation. Rebecca, one for you. What is the likely effect of this decision and its fallout on state programmatic general permits? That is, permits that the Corps of Engineers has entered into with various states to coordinate permitting or function, and particularly effect on mitigation programs that that relate to some of these cooperative ventures.
Yeah, I think that's something we've thought some about. I think at least in the compensatory mitigation, there's coordination where states have regulatory programs or compensatory mitigation requirements. There's a lot of coordination with the Corps and the state. The state often sits on the interagency review team, especially in states that have permitting programs for wetlands, and so are part of the decision-making team for compensatory mitigation projects and programs. So I think the Corps also does the jurisdictional determinations oftentimes for the state permitting. So I think that there's potential for more of the administrative burden to go to the states, without the lack of that partner in the Corps on a lot of these decisions. And I think that goes to the state programmatic general permits as well, which are coordinating efforts with the Corps on the 404 permits. So I think those are likely to change substantially. If for waters that are non-WOTUS waters now. but the state will, have to take over that part of the program.
Thanks. There are a number of questions that relate to functions of other federal agencies that might have jurisdiction for various purposes, or that are landowners or the like, Bureau of Land Management, Fish and Wildlife Service. To what extent do other federal agencies have an opportunity or option to step in and provide protections, even if the WOTUS definition doesn't protect these waters? Try Robin on this one.
Yeah, I'll start. Important to remember that Sackett is interpreting a term specific to one statute, the Clean Water Act. And so to the extent that any other regulatory provision, state, federal, or tribal, does not depend on that definition, it can go its own way. Where it is important is if federal jurisdiction under Section 404 was then the trigger for, say, a Section 7 ESA consultation for endangered species, or a NEPA environmental impact analysis requirement. Those will be affected, but any governmental body that has independent jurisdiction to do something else does not have to follow the Supreme Court. And by the way, that includes some states that have assumed Clean Water Act permitting authority, but have adopted it as state law that operates functionally independently from whatever's going on in federal jurisprudence. So, the short answer is, if they had the authority to do it before, and it's not dependent on how WOTUS is defined in the Clean Water Act, they still have the authority.
I want to pose another question for Edward, and this was, you mentioned federally recognized tribes, of which there are a great many. What about non-federally recognized tribes? Do they have a particular set of implications that we should be aware of?
So I think we can separate this into three categories: maybe federally recognized tribes, state recognized tribes, and fully unrecognized tribes. If you're a unrecognized tribe, you've got mass torts, you've got, the ability as citizens of the United States to lobby your state and federal government. As a state recognized tribe, there's a little bit more to act on. Most state recognized tribes are recognized by a state commission. My own tribe is recognized by the Alabama Indian Affairs Commission, which is organized under the governor of Alabama. I know in Hawaii, they don't consider themselves a state recognized tribe, but it's a parallel system of recognition where the Office of Hawaiian Affairs is the tie-in between the government of Hawaii and the Hawaiian people, the Kanaka Maoli. And for example, in North Carolina, the Lumbee have a very tight relationship with their state government. So, I guess the answer is, if you are a state recognized tribe and you have amassed a degree of political influence within your state, then you can act as sort of an arm of that state government and push for a degree of regulation. But there is no federally recognized authority to regulate, despite the fact that state recognized tribes would generally across the board say that they haven't sacrificed their inherent sovereignty. So that's worth mentioning, but I think federally recognized tribes are definitely best positioned to take advantage of the current situation.
Thanks. There are a number of questions that I'm going to throw this one to Jonathan. There are a number of questions that say, in effect, did a whole lot change? Is the Supreme Court basically reining in regulatory overreach, and that the agency should have been aware of all along that they had gone farther than they were entitled to go?
The answer is both. I'm in the camp that the EPA and Army Corps have been on notice that their regulations were problematic, at least since 1995. There's a great Richard Lazarus column from the Environmental Forum from the late 90s pointing out that in the wake of the Lopez decision and the way that altered the way we understand federal jurisdiction under the Commerce Clause, the EPA and the Army Corps stuck their heads in the sand and maintained a definition of waters that was just facially incompatible with the Supreme Court's understanding of the scope of Commerce Clause authority. And that's part of what led to Swank. And the reason the court wrote the Swank opinion the way it did. And so on the one hand, and I guess, until the relevant language that was a problem in the regulations about conditional effects on interstate commerce, not even actual effects, let alone significant effects being sufficient for jurisdiction, wasn't fixed until the Biden administration very recently. So on the one hand, the EPA and the Army Corps in some respects have been, out over their skis or, regulating without a net, whatever the right metaphor is for a long period of time. That said, the aggressiveness of the majority opinion in this case is certainly more aggressive than what the court did in Swank, clearly more aggressive than what a majority of the court was willing to do in Rapanos. So it's both. I mean, in some respects, the EPA and Army Corps have for a long time been interpreting the Clean Water Act in ways that were very legally vulnerable. The day of reckoning didn't come until a court as conservative as the current court was willing to address it. And what's interesting, and we didn't talk about this before, there's a footnote in the Alito opinion that no justice contests that says from the standpoint of statutory stare decisis, there was no controlling opinion in Rapanos. So nothing's being overturned. And so there's not a precedential concern. On the one hand, that makes it much easier for the majority to blow through the Kennedy significant nexus test and throw it aside. On the other hand, it means that this opinion might not be as much of an augur for what we're going to see in other environmental regulatory contexts where there is a clear majority opinion interpreting statutory language that would have precedential effect. So while you have a more aggressive and more conservative court in that respect, doesn't mean programs across the board are vulnerable. There were things about both the way the EPA and Army Corps had been operating and the precarious nature of Rapanos that created an additional vulnerability here that you might not see in other environmental regulatory programs.
I have some questions related to assumption, and assumption, of course, being the program under which states and presumably tribes could undertake operation of much of the 404 program on getting federal approval. And the 3 states have assumption, the most recent being Florida. Let me throw this to Rebecca. So are states more or less likely to seek assumption, given the change in the amount of waters that are covered by waters in the U.S.?
A really good question. I might ask this panel that as well. I don't know. I know that prior to this, there were a number of states that were moving in that direction. I know Minnesota had talked about, Arizona, I think Alaska, I've heard. So I don't know, if this will change their motivation for seeking assumption, and if that's something that they'll still pursue. I think it will be interesting to see. So Robin, did you have a thought?
Yeah, I just want to throw in, one thing this decision does is narrow the numbers of waters you can assume, because 404 has always had a carve out for the truly federal waters, in part in deference to the Rivers and Harbors Act as well. And so unlike 402 that doesn't have that carve out where you can just take whatever, you never could take that much. And I think it remains to be seen how much is actually left to assume through 404, depending on where we go with the jurisdiction. So it's a hassle for states to do. Witness Florida's recent attempt for fewer and fewer waters to get control over. So I would bet most of them, I mean, there's never been a great rush to do it, face it. So I don't see this encouraging more states to try.
We're just about at the end of our time. I do want to have our panelists have an opportunity to respond to what do you think the chances are for federal legislative responses, even in part to this decision or aspects of the decision. I'll start with Jonathan and then go Edward, Rebecca, and Robin.
And I think the short answer is there's not currently the stomach for expanding EPA and Army Corps' regulatory authority. But one thing at least to think about is we saw in the wake of West Virginia versus EPA, a willingness of Congress to shift from thinking of regulatory strategies to address greenhouse gas emissions to fiscal strategies. That both produces less political opposition and procedurally it's easier to get through the legislative process. And there are various programs, and certainly Congress could create additional programs that would use incentives, conservation easements, land purchases, other sorts of things as ways of inducing greater conservation. If there's a legislative response that can get across the finish line, I think in the current political environment, that's the sort of thing that would be the most viable.
Thanks. Anyone else?
I think Jonathan gave a great answer, so I'm going to hold off on adding to that.
Agreed.
Yeah, I agree. And if they tried to actually, which I think there would be more political stomach for right now, codify a narrowed jurisdiction, that actually gets very hard to do. And I don't know that they could meet the requisite clear statement requirement from this court.
Okay, I'm going to leave it there. And I thank all the people who've joined us for today's webinar. Many things to be considered. I will note that some of the materials Rebecca referred to with a map, which is necessarily an aggregation and simplification, is based on a couple of articles and materials that are linked on the ELI website. If you go to events and the archive, you'll find this event and the specific details as to what extent states actually do rely on WOTUS or 401 or the like is documented to the extent you can there. Other great materials. Thank you to all of our panelists. I look forward to many conversations in the future as we puzzle this out, and I'll throw it back to Madison to finish off.
Thank you so much to our esteemed panelists and our moderator, Jim, Jonathan, Robin, Rebecca, and Edward. Thank you all so much for joining us today. We so appreciate your time, energy, and your willingness to analyze this decision and speak with us about it. Thank you to our audience for your engagement and your thoughtful questions as well. If this webinar or our wetlands work has been of value to you in your work, we invite you to donate to ELI and help make laws that work for people, places, and the planet, most especially our wetlands. You can text the word wetlands to the number 707070 to donate. Please check out other ELI events on our events webpage located at eli.org. A recording of this webinar will be posted to the event webpage within a few business days of the event. Should you have any questions, please reach out to us at events@eli.org. Have a great day, and we hope to see you at another event this summer. Thank you all again.
Yeah.
Thank you all.